Can an heir get reimbursed from the estate for expenses they say they paid after the death? And what proof do they have to provide? Sometimes, an heir is not automatically entitled to repayment just because they paid bills after a death. Reimbursement usually depends on whether the expense was the estate's responsibility, like a necessary cost of administering the estate or a valid debt of the decedent or estate, and whether the expense actually benefited the estate and was reasonably necessary. The administrator has to account for estate money, and the court clerk who oversees the estate can require support for any disbursement, including reimbursements to an heir. So the heir needs solid, itemized proof showing what was paid, the date, who was paid, why it was necessary, the amount, and proof the heir actually paid it. That typically means receipts, invoices marked paid, and bank or credit card records, not just a bill, an estimate, or a handwritten list. If an expense is mixed between estate needs and personal or discretionary spending, the reimbursable part can be reduced or denied unless it is clearly separated. And with real property, the clerk may scrutinize whether the cost was truly an estate administration expense, like preventing damage or keeping required insurance in place, or whether it was really a cost the heirs should bear as future owners. Practically, the heir should submit the request and documentation to the administrator early so it can be handled properly on the next accounting, and other heirs can object if they believe the reimbursement is not appropriate.